Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay, so first of all, for Orange, let's go ahead and get appearances for the state.
Connor Ellis on behalf of the state.
For the public defender.
Dominique Cunningham on behalf of the Office of the Public Defender, Your Honor.
Okay, welcome. Do we have Mr. St. Louis? Yes. Okay, welcome, Mr. St. Louis. You're here today for an initial appearance on a charge of second-degree murder. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Sure.
Okay, I'll go ahead and appoint the public defender. Okay, I've reviewed the materials to the extent necessary. I'll find probable cause. And at this time, I'll direct that Mr. St. Louis be held without bond.
May I have a moment, Your Honor?
And thank you, sir. That will conclude your initial appearance. Okay. So next, and how many Spanish cases do we have?
It should be until we get to the Portuguese. Not really any. So Judge, when you done with what I affidavit, you put it right here. Yeah, no.
Sorry about that.
It's a little different, but
Okay, I'm sorry. Okay, I'm going to call the Spanish interpreter, and then we can do the Spanish interpreter cases next.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Okay, great. So I've got, we'll do the Spanish interpreter cases next. I see that we have a Portuguese case as well. Is that you, or would that be another interpreter?
That would be another interpreter. I'm not sure, Your Honor. I did not get any information regarding that. I was only informed regarding the ASL, so I apologize.
you have to find the language line on the Portuguese. The language line.
Okay, the clerk is helping me out with that. Thank you very much, sir. Next case I have is Mr. Rivera Luciano.
And do we have a case number for that, Judge?
It is 2022 CF 002601.
Thank you, Your Honor.
Okay. Welcome, Mr. Rivera Luciano. You're here today for an initial appearance.
Your Honor, my apologies for interrupting. I could not hear him. I just want to make sure that he can hear me and that he's speaking into the microphone on the podium.
He has the headset on. Can you just go ahead?
Yes, Your Honor. I'm just asking him to speak up and to get close to the microphone because when he answered me, I couldn't hear him.
This would be the microphone on his headset, not the microphone.
No, the microphone on the podium is what we need him to speak into. Thank you so much. My apologies, Judge. You can go ahead.
Okay. Good. I just wanted to make sure everything was situated there. Okay. You're here today for an initial appearance on charges of aggravated stalking after an injunction, aggravated stalking with a credible threat, violation of a domestic injunction, contact order, and domestic violence battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
El defensor público ya está viendo este caso porque este caso yo lo estoy viendo de calle.
Yes, the public defender is already handling this case because I'm handling this case on the street.
Your Honor, I believe he may be confused. He is out on ROR for an arson charge in which my office is appointed.
I'll appoint the public defender in this case as well.
Your Honor.
Okay, I've reviewed the materials. I do find probable cause. And let me ask, has there been any contact with the victim in this case? Okay, here's what I'll do. I'll set bond in the amount of $2,500 on count 1, $2,500 on count 2, $1,000 on count 3, $500 on count 4, and I'll maintain the conditions in the warrant: no contact with any victim or witness, no return to the location of the offense, abide by any injunction in place, no possession of weapons, firearms, or ammunition. In addition, Mr. Rivera Luciano is out on ROR in case number 2021 CF 013201. In that case, I'll revoke the ROR and direct that Mr. Rivera Luciano be held without bond at this time. And with that, sir, that will conclude your initial appearance. Thank you very much. Next, I've got Gonzalo Pinto-Lara.
I'm sorry, Your Honor, could you spell that last name for the benefit of the interpreter, please?
Sure, I have Pintolara.
Thank you very much, Your Honor.
And this is case number 22 CF 2768. And Mr.
Thank you, Judge.
Mr. Pinto-Lara, you're here today for an initial appearance on charges of possession of an anti-shoplifting or inventory control device, use of an anti-shoplifting or inventory control device, grand theft in the 3rd degree, and larceny retail theft of $750 or more dollars. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Sweet.
Okay, I'll appoint the public
Yes.
defender. Thank you. I'll appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to adjust the bond amounts. For count 1, I'll set bond in the amount of $1,000. Count 2, I'll set bond in the amount of $1,000. Count 3, I'll stay the bond in the amount of $500. Count 4, I'll set bond in the amount of $500. And that will be with the condition of no return to the scene of the offense and no contact with the victim, any witnesses, or co-defendant. And with that, Mr. Pinto-Lara, that will conclude your initial appearance. Thank you very much, sir. Okay. Next, we've got Melanie Riquelme, and this is case number 2022 CF 002745. Okay, welcome, Ms. Riquelme. You're here today for an initial appearance on charges of possession of an anti-shoplifting inventory control device, use of an anti-shoplifting inventory control device, grand theft in the third degree, larceny, retail theft of $750 or more. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel. And if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time? You need to say yes or no out loud.
See.
Yes.
Okay, I'll appoint the public defender at this time. I've reviewed the materials. I do find probable cause. And I'm going to adjust the bond amounts. I'll set bond in the amount of $1,000 on count one, $1,000 on count two. I'll stay the bond in the amount of $500 on count three. And I'll stay the bond in the amount of $500 on count four. That will be with conditions of no return to the scene of the offense and no contact with the victim, any witnesses, or the co-defendant. And with that, that will conclude your initial appearance. Thank you very much. Okay, next we have Ms. Laveris.
Sorry, Your Honor, could you kindly spell that for the benefit of the interpreter, please?
Yes, sir. It's Loveras, and this is case number 22 MM1617.
Thank you, Your Honor.
Ms. Laveris, you're here today for an initial appearance on a charge of domestic violence assault.
I don't know if she needs, I don't know if the victim needs an interpreter. We have a victim.
Okay, one moment. We also, we have a victim here. If someone can inquire as to whether she needs an interpreter? No?
Your Honor, my apologies, Judge. Sorry for jumping in. I was just going to ask the victim in Spanish, but if you've made the determination already, then that's fine.
She's indicated that she does not need an interpreter.
Thank you, Your Honor.
Okay, so thank you very much. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time, ma'am?
No.
No.
Okay. I've reviewed the materials. I do find probable cause. My understanding is that we have a victim here. Yes, ma'am. Can you let us know your name?
Yes, my name is Giovanna Loveras.
Okay. Welcome. I'm going to ask the clerk to please go ahead and swear you in. If you please raise your right hand.
You solemnly swear affirm the testimony you give me the whole truth and nothing but the truth?
I swear.
And what is it that you'd like the court to know in making a determination today? And if you could, please just stop every sentence or so that the interpreter can interpret.
Okay. I just wanted to advise that I did not want to press any charges, and she did not put her hands on me. So I'm not too sure what was the reason she was taking in, but she did not, she did not hit me whatsoever.
Okay. Have there been any prior incidents that have sort of gotten physical between the two of you?
Between the two of us, no, it's only verbally.
Okay. Let me just confirm, does Ms. Loveras qualify for PTR? Okay, here's what I'm going to do. I will direct that Ms. Loveras be released on straight PTR with the condition of no hostile contact. And with that, that will conclude your initial appearance. Thank you very much. And thank you very much, ma'am. I appreciate it. Okay. So my understanding is that was all of the interpreter cases we have. I just want to make sure that none of the victims need interpreters.
I asked earlier, Your Honor, she said no.
Okay, so the answer to that is no then. I think that's all that we need today. Thank you very much. Mr.
You're welcome, Your Honor. Have a good weekend.
You too.
Okay, call
Okay, now we'll need,
the name sign for the Portuguese. Let me call it right quick.
okay, we'll do what we need to for the Portuguese case. So that is Mr. Alan Alves, and we're working on getting the interpreter.
Portuguese is hard. So you just gotta be patient. Portuguese is kind of hard to get them. She don't speak nothing else, just Portuguese, right?
Okay. While we're waiting, I just want to ask, in this case, was there victim contact, and does the victim want to maintain contact?
I believe the victim is present, Your Honor.
Oh, okay.
For a court proceeding. Okay.
Do they think it's going to be a while?
Someone had just came on, she said she's trying to find me. So I don't know how long it's going. Hey, but it's start on. We don't know how long.
Well, let me give you all some options. We're waiting on a Portuguese interpreter. I don't know how long it's going to be. I would tell you that for this one, unless I hear something surprising, I'd be very open to something like straight PTR with no hostile contact. So we've got a few options of seeing if we can get somebody on and calling the case a little bit later. If there's anybody that can communicate in any way, just going forward, and I raise that for consideration. I know we haven't formally appointed the PD yet, but you all think it's best just to recall this one a little bit later on, or?
Your Honor, I think that would be best because there is a victim here that would want to be heard. And so I would.
Oh, we've got one. Never mind. Problem solved.
I need you to transmit it in a court proceeding. I'll put you on hold and judge and answer some questions, okay?
Para falar aqui, né? Pode baixar pouquinho aqui? Ah, de máscara.
Hi, I'm in the Portuguese interpreter. How can I help you?
Okay, welcome. This is Judge Vincent Falcone. We're here for initial appearances in Orange County, Florida. So we just needed your assistance with one person and perhaps a victim who's here in need of a Portuguese interpreter. Can I ask, have you previously been sworn in?
No, I have not.
Okay, I'll ask the trial clerk to please go ahead and swear in the interpreter.
Raise your right hand. Do you solemnly swear to translate from Portuguese to English, from English to Portuguese in the testimony given today?
I do.
State your name and your ID number, please.
Aminda Lame, AMINDA, space LEME, interpreter code Papa Sierra Alpha Alpha.
Okay, so does the victim?
No, he said he don't need it, but she did.
Okay, so I'm being told the alleged victim does not need an interpreter, but Ms. Ellen Corralves does need an interpreter. So, Ms. Ellen Corralves, you're here today for an initial appearance.
Senhora, a senhora está aqui por comparecimento inicial hoje.
Sim.
You have the right to,
Yes.
okay, you're here on a charge of domestic violence battery.
Você está aqui na acusação de assédio, de abuso doméstico.
You have the right to remain silent. Anything that you say here may be used against you.
Você tem o direito de ficar em silêncio. Qualquer coisa que a senhora disse pode ser usado contra a senhora.
Eu não entendi, sorry. Eu não entendi.
I didn't understand what that meant.
Okay, you don't have to say anything here today, and you have the right not to say anything if you don't want to, because anything that you say could be used against you in a criminal proceeding.
Não é necessário a senhora dizer nada hoje, se a senhora não quiser. E qualquer coisa que a senhora dizer pode ser usado contra a senhora no procedimento judicial.
Ok.
You have the right to an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you.
A senhora tem um direito a um advogado. Se a senhora não pode pagar um advogado, tem o defensor público que pode lhe auxiliar.
Would you like the public defender appointed at this time?
A senhora quer um defensor público designado no seu caso?
Pode ser.
Yes.
Okay, I'll appoint the public defender.
Ok, eu vou designar um defensor público.
I've reviewed the materials, and I do find probable cause.
Eu revisei os materiais. Eu acho que tem razão para continuar com isso.
And I understand that we have the alleged victim here.
Eu entendo que também temos a vítima alegada aqui presente.
Sir, can you let us know your name?
My name is Terry Dos Santos.
Senhor,
Your Honor, my name is Terry
Meu
Dos
nome-
Santos.
meu nome é Terry dos Santos.
Okay. I'm going to ask the trial clerk to go ahead and swear you in.
Eu vou pedir,
Do you solemnly swear affirm the testimony you give be the truth, the whole truth, and nothing but the truth?
Yes, I do swear.
eu vou pedir para o agente prestar juramento para você. Você jura dizer a verdade, unicamente a verdade? Sim, eu juro.
Okay, and sir, what is it that you'd like the court to know today? And please stop every sentence or two just so that the interpreter can keep up.
Sim. Your Honor, I don't want to press any charges, okay? I don't want to press any charges against her. I spoke to her doctor this morning, and I told about the medication, the anxiety, you know, the medication that she takes, and he's willing to see her right after court. And I don't want to, anything that she said, I forgive her, and I ask her to forgive me too, with anything that we might have said to each other, and that's all.
Senhor, um momento.
Oh, I'm sorry.
Por favor, fale em frases curtas para que a intérprete possa interpretar. Senhor meritíssimo, eu não quero colocar nenhuma acusação contra ela. Eu já falei com a filha dela hoje, falamos sobre os medicamentos, a ansiedade que ela sente. Eu estou disposto a vê-la, eu quero pedir desculpas para ela e eu quero que ela peça desculpas também. Eu sinto muito por tudo que aconteceu.
Have there been any prior incidents between the two of you that have gotten physical? Just one moment.
Já tiveram algum acontecimento entre vocês dois que terminou sendo uma situação física?
Nunca. Never.
Never. Nunca.
If anything did occur where you were in fear for your safety, would you have any hesitation to call law enforcement?
No. No.
Se,
Not at all.
se Se alguma coisa acontece em algum momento que você tema pela sua vida, você teria um problema em ligar pela ajuda judicial? Não, sem problema nenhum.
Would you be in fear for your safety if Ms. Ellen Corralves were allowed to return to the residence?
Not at all.
Você teme pela sua segurança se a senhora Helena Perelvis pudesse retornar à residência? Não, de jeito nenhum.
Okay, I'll give counsel an opportunity to ask follow-ups if you'd like. State.
No follow-up questions, Your Honor.
Eu vou dar a oportunidade ao promotor se ele quiser dar alguma pergunta de seguimento. Não, sem perguntas, meritíssimo.
In defense?
No further questions, Your Honor.
Defesa, sem mais perguntas, meritíssima.
Okay, thank you very much, sir.
Thank you, sir.
Let me just ask, I just want to confirm, does Ms. Ellen Corralves qualify for PTR? Okay, here's what I'm going to do. I will direct that Ms. Ellen Corralves be released on direct PTR.
Ok, eu só quero perguntar para ver se a senhora Helena qualifica pelo tratamento do DRT. Então, agora vou liberar ela para ter atendimento direto do DRT.
With a condition of no hostile contact.
Com a condição que ela não tenha nenhum tipo de contato hostil.
And with that, that will conclude your initial appearance today. Thank you, ma'am. And thank you very much, sir.
Thank you, Your Honor.
Isso conclui sua aparência hoje. Muito obrigada ao senhor e obrigada à senhora.
Okay, and
Anything else I can do for you, Yona?
well, let me just check on that real quick. My understanding is, oh,
Yes.
okay. Let me,
I think she said that.
okay, then here's what I'll do. I'll release her ROR with the condition of no hostile contact. My understanding is she doesn't qualify for PTR.
Ok, então eu vou liberar a senhora com a instrução de ROR, porque a senhora não qualifica pelo PTRE.
Yes.
What is that?
Oh,
What is that?
Oh, just talk with staff out there and they'll explain it. Or you can talk with your counsel if you'd like.
Pode falar com seu advogado ou funcionário lá fora e eles explicam para a senhora.
Okay. Let me just make sure, is there anybody else that needs a Portuguese interpreter in terms of defendants? Okay, and any of the victims? Okay, I think that's all that we need, Madam Interpreter. Thank you very much.
Okay, you're very welcome, Your Honor. Interpreter is disconnecting. Have a great day.
Thank you.
Bye.
Your Honor, I believe the next case has a private attorney. May I have just 2 minutes
Yes.
while you do this one?
Okay, well, and what I also am going to say is that
Thank you.
I'm
Goodbye.
going to keep going unless somebody tells me they need a break. So anytime any of you need a break, just let me know. But you can go ahead and step out. And
is it in felony? Where's this case is in? His name. So it's in. He just didn't give me his name to pull out. Last name is. What's the name of the master?
I think he might have been further back. Let me see if I can.
Was it a reset? N-A-S. N is in Nancy. Okay. You found the judge?
Got it.
Okay. Oh, okay, okay. Oh, I got, oh, there's a lot of felony DPs. Got it. Okay. Ooh,
Okay, let me get appearances. We've got the state for defendant.
Good morning, Your Honor. No, good afternoon, Your Honor. Scott Messinger from Mandel Law for Mr. Matrai, Nartazajev.
Okay, welcome, sir. Give me one moment. Okay, Mr. Nartaziev, you're here today for an initial appearance on a charge of domestic violence battery. You have the right to remain silent. Anything that you say here may be used against you. I've reviewed the materials. I do find probable cause. And my understanding is that the alleged victim is here. Ma'am, can you just let us know your name?
My name is Madina Zumanova, Zhumanova.
Okay, welcome. I'm going to ask the trial clerk to please go ahead and swear you in. Please raise, if you can, raise your right hand.
Do you solemnly swear affirm the testimony you give be the truth, the whole truth, and nothing but the truth?
Yes, true.
Okay, what is it that you'd like the court to know?
I would advise do not charge him, overall he's a nice person. He hit me because of his mom. His mom doesn't like me at all, and he was against our marriage.
Okay, have there been prior times where things have gotten physical between the two of you?
Yes, it was physical.
Okay, how many times in the past? Is it a common occurrence?
One time, it was yesterday one time.
Okay, other than that, other than yesterday, are there times that things have gotten physical?
No, it wasn't like verbally, more verbally.
If Mr. Nartaziev were allowed to return to the home, to the residence, would you be in fear for your safety?
No, I'm not scared. I'm not scared.
Okay, if anything did happen where you were in fear for your safety, if things got very aggressive or physical, would you have any hesitation to call the police?
No, I don't have anything. You can put just no like a hassle, no angry, but I'm not scared at all.
Okay, I'll give the parties an opportunity to ask follow-up questions if they would like. State?
No further questions, Your Honor.
Okay, defense?
Thank you, Your Honor. And for the record, Scott Messinger. Good afternoon, Ms. Medina.
Good afternoon.
So, did you tell the court that you do want Iskander to go back to the house?
Yes, I wanna.
Okay, and you and I talked before, and I explained to you what no hostile contact meant. Is that right?
Yes.
And you just told the court that. May I ask you, you understand what no hostile contact means?
Yes.
And there's another child at home with you and Iskander, is that right?
Yes.
And you also have a son at home who is Iskander's stepson.
Yes.
And Iskander provides support for the whole family, is that correct?
Yes.
And you said there was no alcohol or drugs involved in the incident occurred yesterday.
Yesterday, no.
And unfortunately, there was a mother-in-law. There's a whole bunch of jokes about that in American culture, but anyway, I'll cut to the chase. She is out of the house now, correct?
Yes.
Yes. Excellent. Thank you, ma'am.
No problem.
Okay, on this one, I'll hear from the parties on proposed conditions of release. State?
Your Honor, it does seem that he qualifies for pretrial release, so the state would not have an objection to that. We would order no hostile contact, and I think that would be probably as well no weapons or firearms, but besides that, I think that would suffice.
Okay, defense?
Thank you, Your Honor. I wanted to supplement the record and tell the court that Mr. May I say Iskander, his first name? Mr. Iskander is a U.S. citizen. He's been in this area for years. He has a stable residence that he pays for, good residence from what I understand. He's a high-ranking employee at MLL Logistics. He has a commercial driver's license, and he has worked in that job for years, owns his own home, and does contribute, I think, primary, by far, contributor of the maintenance of the house. I have talked to Mr. Iskander, and I told him that what no hostile contact meant. I also told him what no contact meant, and that if the court were to permit Mr. Iskander to go back home, it would do him well to get an evaluation for anger management or get some counseling for anger issues. Thank you, Your Honor.
Okay, and is it correct that Mr. Nartaziev qualifies for PTR? Here's what I'm going to do. I'll set bond in the amount of $250 with PTR conditions. In addition, a condition of no hostile contact. And a condition that Mr. Nartaziev surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. With that, sir, that will conclude your initial appearance. Thank you very much. Thank you very much, ma'am.
Thank you, Honor.
And I thank the court for letting me skip to the front of the line.
Absolutely. Is that your only case for today?
Yes, sir, it is.
Thank you very much.
Thank you, Your Honor. Good afternoon, sir.
Hope you have a good day. Okay. Next one that I have is Natisha Clark. Ms. Clark?
Sure.
Okay, welcome. You can step up to the microphone. You're here today for an initial appearance on charges of petite theft with prior conviction, petite theft retail, and resisting a merchant. You have the right to remain silent. Anything that you say today may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender's office. I've reviewed the materials. I do find probable cause. And I'm going to stay the bonds in the amount of $500 for count 1, $100 for count 2, $100 for count 3, and that will be with the condition of no return to the scene of the offense. And with that, that will conclude your initial appearance. Thank you very much.
Thank you.
Thank you. Okay. Do we have Mr. Freeman?
Yes.
Okay, welcome, Mr. Freeman. You're here today for an initial appearance on a charge of aggravated battery causing great bodily harm with a firearm. You have the right to remain silent. Anything that you say may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
No, I already have an attorney.
Okay, then I will not appoint the public defender. To the extent necessary, I do find probable cause. I'll stay the bond in the amount of $25,000. I'll maintain the conditions from the warrant. That's no return to the scene of the offense, no contact with the alleged victim, and surrender and I'll say surrender weapons or firearms to law enforcement within 24 hours, and do not possess weapons or firearms. And with that, sir, that will conclude your initial appearance. Thank you very much. It's $25,000.
Your Honor, Scott James is behavior.
Okay. For Mr. James, we could either go forward if you're willing to waive appearance and get, well, I guess the bond's already been set over. We can reset it for tomorrow.
Your Honor, I'd ask to reset this for the possibility of maybe resolving this case tomorrow.
Okay, let's go ahead and we will roll Mr. Scott until tomorrow. Okay, do we have Mr. Charlton? Okay, welcome, Mr. Charlton. You're here today for an initial appearance in two matters. In the first case, you've been charged with fleeing or attempting to elude a law enforcement officer and trafficking in MDMA, and also possession of cannabis with intent to sell or deliver. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time? Okay, I'll go ahead and appoint the public defender.
He should have another case.
There is.
Oh, okay, okay.
In the first case, which is 2022 CF 002741, I've reviewed the materials. I do find probable cause. On count 1, which is the fleeing, attempting to elude count, I will set bond in the amount of $2,500. On count 2, which is a trafficking count, I will stay the bond in the amount of $50,000. On count 3, which is the possession of cannabis with intent to sell or deliver, I will stay the bond in the amount of $1,000. And that will be with the condition of no possession or consumption of alcohol or drugs without a prescription.
Your Honor, may I be heard?
Yes.
Your Honor, we would ask for count 2, the $50,000 bond be reduced to an affordable amount that Mr. Charlton can afford. He did state that he wouldn't be able to post bond at that high of an amount, so we would ask if the court would be willing to reduce that.
Okay, what amount would Mr. Charlton be able to afford?
Your Honor, if we could reduce that to a $20,000 bond?
Okay, I'll adjust the bond for count 2 and set that at $20,000.
Thank you, Your Honor.
Okay, now there's another case that you're here for. That's case number 2022 MM001158. In that case, you're here for an initial appearance on a charge of domestic violence battery. Same instructions as before continue to apply. I'll appoint the public defender in that case as well. Reviewed the materials. I do find probable cause, and I understand that the alleged victim is here. What is your name?
Shantisha Walker.
Okay, thank you. I'm going to go ahead and ask the trial clerk to swear you in.
Raise your right hand. Do you solemnly swear affirm the testimony you give be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, and what is it that you'd like the court to know?
I would not like to press charges, and I would like contact with the inmate.
Okay. Let me just ask, have there been prior instances where things have gotten physical between the two of you?
No.
Would you be in fear for your safety if Mr. Charlton were to have contact with you, return to the residence?
No.
Okay, and if anything did occur where you had fear for your safety, if there was any kind of a physical altercation or things got heated, would you call law enforcement?
No.
You would not?
Would I call law enforcement?
If you were in fear for your safety?
Oh, yes.
Okay, I'll give the parties an opportunity to ask follow-up questions. State?
No follow-up questions, Your Honor.
Defense?
Your Honor, I do not have any follow-up questions, but I would like to be heard on the bond in this.
Okay. Here's what I'm going to do. I'll give both parties an opportunity to provide input on bond and conditions of release. I'll hear from the defense first.
Your Honor, at this time, due to the testimony that was given from the victim here today, and this is a misdemeanor domestic violence, he does appear to qualify for a pretrial release. We would ask for him to be released on straight pretrial release with the conditions of no hostile contact in this case.
Good. State?
Your Honor, while he does, I guess, qualify for PTR, the state's position is that we're going to object to that, just given to some of his history. He does have a prior kidnap domestic violence arrests and 2 other domestic violence arrests, ones that he did plead no contest to in 2014. So based on that, we're going to say that bond needs to be set.
Okay, so you're asking for monetary bond. What about other conditions of release?
Other conditions, Your Honor, no hostile contact, no alcohol or drugs without prescription, and no drugs or firearms. I think that given that she wants contact, I think that would be fair.
Okay, here's what I'm going to do. I will, given the priors, I'm going to set bond in the amount of $500 with conditions of pretrial release. In addition, no hostile contact. Mr. Charlton will need to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms.
Judge, on the warrant, because it's a warrant, it had no contact with victim or witness, even from the jail, and maintain separate residence. You striking those? Was it given on hostile? It was a warrant.
Okay, hang on one moment. Here's what I'm going to do, because it is a warrant. I'm going to set bond in the amount of $500. Okay, for the time being, I'm going to maintain the bond conditions for the time being, so that will be no contact with the victim or witnesses, even from jail, maintain separate residences. There can be a one-time assist, one-time return with assistance from law enforcement, and surrender and do not possess weapons or firearms. Just because this is a warrant, I'll leave it to you all to get in front of the presiding judge to argue for adjustment of those conditions. So we'll maintain the conditions in the warrant.
Thank you, Your Honor.
Plus PTR or just 500?
Just 500 with the conditions in the warrant.
Okay.
So no, 500 with the conditions in the warrant. Okay, thank you all very much. With that, that concludes your initial appearance. Thank you, ma'am. Okay, next I've got Nathan Fisher, is that correct? Okay, welcome, Mr. Fisher. You're here today for an initial appearance. You're here on charges of domestic violence, battery by strangulation, false imprisonment, domestic violence, and domestic violence battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed?
Yes.
Yeah, I'll go ahead and appoint the public defender.
Your Honor, may I be heard on probable cause for the false imprisonment charge?
Yes, ma'am.
Your Honor, at this time, the defense takes the position that there is no probable cause for a false imprisonment. The affidavit within the 4 corners does not show that there was any confinement, any abduction, imprisonment, or restraint. For those reasons, we'd ask the judge to ROR on the false imprisonment charge.
The state?
Your Honor, the state is going to argue that there is probable cause for the false imprisonment within these 4 corners because he did take the victim's car and left her there, and she would have had no other way to leave if she needed to.
Your Honor, if I may?
Yes.
With those facts, that does not prove a false imprisonment. It just proves that she doesn't have anywhere to go. She was not confined in any place. She was able to walk away. No one was holding her anywhere. So based off of the elements that the state would have to show if this case went to trial, there is no probable cause for a false imprisonment.
Okay. I don't think at this point, the affidavit gets you there. Would you like a?
We would ask for a reset, Your Honor.
Okay, then.
Your Honor.
Yes.
I would object to a reset. There's no extenuating circumstances within the four corners of the document which would show that the state has met their burden to get the 24 hours to supplement the affidavit. The affidavit does appear to be complete, so we would object to a reset in this case.
I'm going to allow a reset for a further opportunity on that, and at this point, do you want to proceed with the other 2 counts?
Your Honor, if this is going to be reset for 24 hours, then we would ask for it all to be heard at the same time.
Okay, then all of it will be reset. We'll do a 24-hour reset for Mr. Fisher.
So, as to count 2, no, reset for PC and count 2, correct?
We're resetting for PC, yes.
Yeah, the whole case, yeah. But I mean, yeah, he's not saying no bond or nothing, I just put on here 4 hours.
And Your Honor, I apologize. This is going to be reset for tomorrow.
I think so, yes. Yeah, it'll be reset for tomorrow.
Thank you, Your Honor.
I'll be here tomorrow.
Okay, do we have Mr. Green?
Sir.
Okay, welcome, sir. You're here today for an initial appearance on charges of tampering with a witness to hinder communications to law enforcement, domestic violence battery. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford counsel, the public defender's office will be appointed to represent you. I've got information here that you do not qualify for appointment of the public defender. So I've reviewed the materials. I do find probable cause. And has there been any communication with the alleged victim?
Yes, sir. Contact was made with the victim and stated she would not be able to attend.
I'm sorry, she'd not be able to?
She stated she would not be able to attend.
Okay. And do we know whether did the victim indicate whether contact was desired?
No, sir, she did not.
Okay. So at this time, on count 1, I'm going to set bond in the amount of $1,000. On count 2, I'll set bond in the amount of $1,000. That will be with conditions of I'm going to maintain those conditions. Well, I'm going to maintain that bond. So no PTR, but there will be conditions of no contact with the alleged victim except matters of child care may be discussed through a third party. Mr. Green will need to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. And Mr. Green shall not consume or possess alcohol or drugs without a prescription. And with that, sir, that will conclude your initial appearance. Thank you very much. Okay, do we have Ms. James Price?
Yes, sir.
Okay, welcome, ma'am. You're here today for an initial appearance on charges of domestic violence, aggravated assault, and domestic violence battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. And I understand that we have the alleged victim here. Can you let us know your name, please?
Erica Brown.
Okay, welcome. I'm going to ask the trial clerk to go ahead and swear you in.
Raise your right hand. Do you solemnly swear affirm the testimony you shall give be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, what is it that you'd like the court to know today?
That I didn't want to press any charges.
Okay, do you desire to have continued contact with Ms. James Price? Do you want her to return to the residence?
Yes, sir.
Have there been any prior incidents where things have gotten physical between the two of you all?
No, sir.
Would you be in fear for your safety if Ms. James Price were to return to the residence?
No, sir.
If there was an issue where you became afraid because things were getting physical or very heated, would you call law enforcement?
Yes. Yes, sir.
I'm going to go ahead and give the parties an opportunity to ask any follow-up questions. State?
No further questions, Your Honor.
Defense?
The defense has no questions at this time, Your Honor.
Okay. Just one moment. Okay, let me just ask if I were to direct separate residences for the time being, would Ms. James Price have somewhere else to stay?
No.
There's not a friend or family member that you'd be able to stay with for?
No, I have, all my family is out of the state, and we moved together. We don't know anybody here. We just moved here from another area down south.
Okay, would you be able to afford a temporary place, either a hotel or?
No, because I had just started working, and I don't even have a paycheck.
Okay, let me hear from the parties on conditions of release. Defense, I'll ask you first.
Your Honor, due to the testimony that was given by the witness today, the witness states that they would call law enforcement if there were any issues that were to occur. Law enforcement was called in this case, so we would ask for there to be no hostile contact and for them to be able to maintain a residence together.
Okay, State.
Your Honor, I do understand, or the state's position that while the victim has requested contact, given the facts of this case, the alleged facts of this case, the state at this time would still request no contact, at least for the interim. She does have another simple assault arrest out of state, as well as another battery. So the state would be concerned, just due to the facts of this case. We would ask for no contact and at the least no hostile contact.
Let me ask, ma'am, if you had to stay somewhere else for a period of time, is that something that you could do, or is there any friend or family member you'd be able to stay with?
I would do that as long as she could be able to go back to the house. Like, I wouldn't want her to be able to go back, to the house.
Okay, what I'm saying is if, until this issue could be addressed further with the judge who's assigned to the case, if Ms. James Price were to go back to the residence, do you have someplace that you could stay for a period of time?
Yes.
Okay, here's what I'm going to do, just because I recognize the testimony, but what's in the arrest affidavit, if it occurred then I would have concerns about contact and staying in the same residences. I recognize that it indicates that the story shifted for some period of time, but just because this is an initial appearance, what I'm going to do is set bond for count one in the amount of $2,500, set bond for count two in the amount of $500, going to set conditions of no contact with the alleged victim, maintain separate residences with a one-time return, maintain separate residences, and I understand that Ms. Brown would then be looking for a place to stay while you all attempt to get in front of the presiding judge. I will direct that Ms. James Price surrender any weapons or firearms to law enforcement within 24 hours, not possess weapons or firearms, and no possession or consumption of alcohol or drugs without a prescription. Okay, and with that, that will conclude your initial appearance. Thank you very much, ma'am. Thank you, ma'am. Appreciate it. Okay, do we have, is it Mr. Nutter?
Yes, sir.
Okay, welcome, sir. You're here today for an initial appearance on charges of aggravated battery and dating violence battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the Public Defender's Office will be appointed to represent you. The material that I have here indicates that you do not qualify for the Public Defender, so the Public Defender will not be appointed. I reviewed the materials. I do find probable cause.
Your Honor, as a friend of the court, may I make a probable cause argument?
I don't think so. I've reviewed the affidavit. I recognize it's brief, but I think that there is enough there that I'm comfortable finding probable cause at this time. So what I'm going to do is let me ask, has there been any contact with the alleged victim?
No, Judge, no contact was left with the victim, but a voicemail was left on the victim's voicemail.
Okay. What I'm going to do is I will set bond in the amount of
Your Honor?
Yes.
Can we reevaluate the amount that Mr. Nutter does make? He did express the amount that is on the paperwork is what his business makes, not what he makes. So if we could inquire about his income.
Okay. Sir, I'll inquire about your income. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. What is your income?
After I pay my 2 employees, fees, everything, to keep my business running, it's roughly maybe $2,500 to $3,000.
Give us that amount again.
$2,500 to $3,000.
Okay, so that is then the net income that you would receive from your business?
Yes.
Okay, with that amount?
What, monthly or weekly?
Is that monthly or weekly?
Monthly.
He have any dependents?
Do you have any dependents?
No, I do not.
Okay.
No, he still don't qualify.
Still does not qualify. Okay, so what I'm going to do is I will set bond on count 1 in the amount of $2,500. I'll set bond on count 2 in the amount of $500. That will be with conditions of no contact, maintain separate residences with a one-time return with the assistance of law enforcement to obtain any possessions, surrender any weapons or firearms to law enforcement within 24 hours, and do not possess weapons or firearms. And with that, sir, that will conclude your initial appearance. Thank you very much. Okay, do we have Mr. Vasquez?
Yes, sir.
Okay, welcome, Mr. Vasquez. You're here today for an initial appearance. You're here on charges of tampering with a witness to hinder communication to law enforcement, domestic violence, battery. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. And my understanding is we have the alleged victim here. What's your name, ma'am?
Juana Manuel.
Okay, I'm going to ask the trial clerk to please swear you in.
Raise your right hand. Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth? Yes, ma'am.
Okay, and what is it that you'd like the court to know?
I want him to be able to come back home. I'm his mom. However, he needs to be mandated to take his medicine because we've been down this road before where he stops and we've had this same thing happen. I want him to come home, but can he be mandated to take his medicine?
Okay, and I just also want to ask you, I heard everything you said, but it was a little low, so if you could just get closer to the microphone.
Sure, sorry.
It's okay, it's okay. If Mr. Vasquez were to return to the home and take his medication regularly, would you be in fear for your safety?
No.
Have there been prior incidents where things have gotten, very aggressive or physical?
Yes.
Did they all involve situations where Mr. Vasquez had not taken his medicine?
Correct.
Okay. Let me see how I want to phrase this. How regularly does he take his medication? How willing is he to take it? Is it something that you think would occur in the future, or would we potentially be back here with the same problem?
I mean, that if he's mandated and he wants to come home, he's probably going to take it.
Okay. Has he indicated an unwillingness to take his medication in the past?
Well, we've been going to the doctor and he doesn't want to take it.
Okay. If there were a situation where things got heated or violent, would you hesitate to call law enforcement?
No, sir.
I'll give the parties an opportunity to ask follow-up questions. State?
No further questions, Your Honor.
Defense?
Are you Mr. Vasquez's primary caretaker?
Yes, ma'am.
And how long has he had a mental health diagnosis?
Since he was born.
When he does take his medication, is he violent?
No.
Are you afraid of him in any way on his medication?
No.
No further questions, Your Honor.
Okay, I'm going to hear from the parties on bond amount, proposed conditions of release. And let me just also confirm, does Mr. Vasquez qualify for PTR?
Yes, sir.
Okay. I'll hear from the state first.
Your Honor, this one's a tough one for the state, given that this is his mother and she would like him to come home. For the court's knowledge, he does have 3 prior domestic battery arrests, so he does have priors here. The state would request for the pretrial release if we could do the mental health pretrial release possibly. So he is held accountable to taking his medicine. We would also request no hostile contact, no alcohol or drugs without prescriptions, no weapons or firearms, if he was allowed to go back into this house.
Okay, so if it were mental health PTR with those conditions, any issue with that, defense, or anything you'd like to be heard on?
No, Your Honor, we believe that mental health pretrial release would be appropriate in this case.
Okay, here's what I'll do. I will order mental health PTR without a monetary bond. That will be with conditions of no hostile contact, no possession or consumption of alcohol or drugs without a prescription. Mr. Vasquez will need to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms.
Judge, with the mental health pretrial release, if he qualifies, it's gonna take a few days, maybe up to 5 days before they even just see him. And then if he don't qualify, he will come back to court for them to set him a bond. So, I mean, he won't get seen by mental health right away. It's gonna take a few days. And then he has to qualify further. So I don't know if he'll qualify or not.
Okay, so if he doesn't,
And then if he don't qualify, it will be set him to come back to court, which I don't know may take what? She was saying, put him on bond or pretrial release. Pretrial release was still, you said for him to take take all medication or, you know, whatever, they will make sure he do that. But if we put him on mental health pretrial release, he had to go through a process which will take about a week before they come see him. And then he may not qualify, then they're gonna have to make another week to bring him back.
so what I'm hearing is a logistical problem. Mental health PTR, it'll take time to evaluate Mr. Vasquez, and if he does not qualify, he would then be returned here. As an alternative, how about a condition that Mr. Vasquez take his medication as prescribed by his physician? Defense, any objection to that?
Would that be just through straight pretrial release?
That would be with straight pretrial release with that added condition.
No objection, Your Honor.
Then that's what we'll do. It'll be just straight pretrial release with an added condition, in addition to the ones that I've just gone through, that Mr. Vasquez take medication for his mental health condition as directed by his physician.
Judge, can I ask you a question?
Yes, ma'am.
Can you ask him if he's willing to take the medicine, if he wants to come home and take his medicine?
Your Honor, I did speak with my client, and he did state that he would be taking his medication.
Okay, so the answer to that is yes. Then.
Thank you.
Thank you. You have what you need? Yes. Okay, then that will conclude your initial appearance today. Thank you very much, sir, and thank you, ma'am. I appreciate you appearing today.
So he's going to be released or no?
Yes, he'll be released with certain conditions, including that he take his medication.
Thank you, sir.
Thank you.
Oh, my God.
Take medication for his mental health condition as directed by his physician.
It was very convincing.
Hey, all right. Do we have, is it Mr. Dixon?
Sir.
Okay, welcome. You're here for an initial appearance on a charge of domestic violence assault. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender's office. I've reviewed the materials. I do find probable cause. Let me ask, has there been any communication with the alleged victim?
No contact.
Okay. Here's what I'm going to do. I'll set, does Mr. Dixon qualify for pretrial release?
No, sir.
Okay. I'll set bond in the amount of $250. That will be with conditions of no contact, maintain separate, no contact with the victim, maintain separate residences with a one-time assist with, one-time return with law enforcement assist to obtain any possessions. And Mr. Dixon will be required to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. And with that, sir, that will conclude your initial appearance. Thank you very much.
One moment.
Oh, yes, I'm sorry.
Thank you, Your Honor.
Thank you very much. Okay, do we have Ms. Fincher?
Yes, Lakeisha Fincher.
Okay, welcome, Ms. Fincher. You're here today for an initial appearance on a charge of domestic violence battery. You have the right to remain silent. Anything that you say today may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Not right now.
Okay, then I will not appoint the public defender. I've reviewed the materials. I do find probable cause. Let me hear from the state on proposed conditions of release and bond amount. Do you have any input on this one?
Your Honor, the conditions that the state would ask would be no contact, no drugs or alcohol, no weapons or firearms, and that is it.
Okay. Give me one moment. Okay, here's what I'm going to do. I'll set bond in the amount of $250. That will be with conditions of no contact with the alleged victim, no possession or consumption of alcohol or drugs without a prescription. Ms. Fincher will need to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. In addition, Ms. Fincher is out on bond and PTR in case number 2022 MM1134. And and in that case, I will revoke the bond and PTR and direct that Ms. Fincher be held without bond until she can get in front of the presiding judge. So with that, ma'am, that will conclude your initial appearance. Thank you very much. This is
No.
2022.
Oh, it's 21.
Excuse me, sir, but I work.
I've got 2020.
No,
In the middle, go down to the.
I'm sorry. I'm going to hear from you. Just let me say real quick that the case number was 2021 CF 008768.
Thank you. And she had a PD in that case, Judge.
Okay, so you do have the public defender in that case. And
May I have a public defender at this point because I've claimed self-defense.
okay, so do you,
Claiming self-defense.
let me just ask you, do you want the public defender appointed?
Yes, I do.
Okay, I'll go ahead and appoint the public defender.
I am claiming self-defense.
Your Honor, may I have a moment?
Yes, why don't you confer with your attorney?
It looks like you're out on bond actually in a meeting. Where you think you can be out on? You have a bond. You're not accepting your bond. The other one is you're out. Thank you, Your Honor.
Okay, thank you very much. Next, do we have Ms. Gillum? Okay, welcome, Ms. Gillum. You're here today for an initial appearance on a charge of domestic violence battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. And my understanding is that we have the alleged victim here. Sir, what is your name?
Lucas Gilbode.
Okay, I'm going to ask the trial clerk to go ahead and swear you in.
Raise your right hand. Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Gilbode, what is it that you would like the court to know today?
I would not like to press any charges, and I would also like to continue contact with the defendant.
Okay, and do the two of you reside together?
No, we live separately.
Okay, if you were to have contact with Ms. Gillum, would you have any fear for your safety?
No, sir.
Has there been any incidents in the past, or have there been any incidents in the past where things have gotten violent between the two of you?
Just verbally, never anything physical.
Okay, only verbally, not physical.
Never physical.
Okay, if there was a situation where things were getting physical or getting very, very heated, and you were in fear for your safety, would you call law enforcement?
Yes, sir.
Okay, let me give the parties an opportunity to ask follow-up questions. State?
I have one follow-up question. There have been no physical altercations between you and Ms. Gillum at all in Massachusetts?
There might one time have been a slap for saying something inappropriate at a wrong time, but other than that, there's never been anything significant, no marks left on each other or anything like that. And
This would have been her slapping you?
Yes.
Okay, no further questions, Your Honor.
Okay, defense?
The incident that you were speaking about, how long ago was that?
4 years ago?
Has there been anything between that incident and the incident that happened last night?
No.
No further questions, Your Honor.
Okay, I'll hear from the parties on bond amount and proposed conditions of release. I'll start with the defense.
Your Honor, Ms. Gillum does qualify for pretrial release. The victim has stated that he would call law enforcement if something happened. He stated that other than the 4 years ago altercation, there has not been anything in between, and he even stated that that incident was minor. There were no marks, and there was nothing other than that. For these reasons, we'd ask for there to be pretrial release and no hostile contact in this case.
Okay, State?
Your Honor, the state's position here is going to be that PTR does seem appropriate. However, based on the history, at least in the stress affidavit and what the victim has said, this happened in Massachusetts while minor, the state does have concerns. So we're going to be asking for no contact. In the event that Your Honor allows contact, no hostile contact, no alcohol or drugs, and no firearms.
Your Honor, if I may?
No, that's okay. I'm satisfied that straight PTR with the condition of no hostile contact is appropriate here. Recognize the state's concerns, but it doesn't appear to me that there were any issues involving alcohol or drugs or weapons that would require those additional conditions. And in terms of the prior incident in Massachusetts, it was reported as part of the investigation here. So that's not something in my mind that's been withheld, and it doesn't appear that it was a major incident. So for all of those reasons, I'll order direct PTR with no hostile contact. Okay, and that will conclude your initial appearance. Thank you very much, ma'am, and thank you, sir. Appreciate you appearing today.
Thank you, Your Honor.
Okay, welcome, sir. Do we have Mr. Jordan?
Mr. Jordan?
Mr. Jordan? Okay. Welcome, Mr. Jordan. You're here today for an initial appearance. You're here on a charge of domestic violence battery, and you have the right to remain silent. Anything that you say today may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause, and my understanding is that we have the alleged victim here. Ma'am, what is your name?
My name is Dawn Allen.
I'm sorry, can you say it again?
My name is Dawn Allen.
Okay, welcome. I'm going to ask the trial clerk to go ahead and swear you in.
Raise your right hand. Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
I do.
Okay, and Ms. Allen, what is it that you'd like the court to know today?
I'd like for you guys to know that me and my boyfriend were simply into an argument. There was a friend around, and she felt like things were getting more than just an argument, but Thomas never hit me.
Okay, have there been any incidents in the past where he has hit you or things have gotten physical?
Never.
Okay, and I see that the two of you reside together. If Mr. Jordan were to return to the residence, would you be in fear for your safety?
No, sir.
If things did get physical or very heated, would you have any hesitation to call law enforcement?
No, I would not.
Okay, I'll give the parties an opportunity to ask follow-up questions. State?
No follow-up questions, Your Honor.
Defense?
No questions, Your Honor.
Okay, thank you very much, ma'am. I'll hear from the parties on proposed conditions of release with respect to the domestic violence battery charge, and there's also, I'll just note a case that Mr. Jordan's out on bond on.
Can I add one thing to it, Your
Yes.
Honor? Mr. Jordan and I have a 5-month-old son at home. I really need his help.
Okay, thank you. No, that is helpful to know. You two have a 5-month-old child together, and if
Provider, sir.
oh, just one moment. If Mr. Jordan were not available, how would it affect your child care situation?
It would keep me from where I couldn't go to work because I can't afford to pay for child care. And therefore, it would affect my income and possibly leave me with nowhere to stay.
Okay. Thank you for that information. So with that, let me go ahead and hear from the parties on proposed bond amount and conditions of release. Defense?
Your Honor, does Mr. Jordan qualify for pretrial release?
Is that because he's out on bond or? Okay.
Your Honor, based on that information, we'd ask for a $250 bond on this case with the conditions of no hostile contact, no drugs or alcohol, and no firearms or weapons. And additionally, Your Honor, we'd ask for this court to take no action on the case that he's out on bond for. The reason for that being, there has been no information filed on that case. It's common practice for the state of Florida not to file on a drug charge until the FDLE report comes back. So it is very often that 33-day motions are granted because FDLE is so backed up. For those reasons, we'd ask for there be no action taken on the case that he is out on bond for.
Okay, State?
Your Honor, the state has no position regarding a bond amount. However, what the state would like to bring is his criminal history. He does have 3 grand thefts, a trespass, a petty theft, a burglary of a dwelling, 7 burglaries of conveyances, a trespass, as well as arrests for possession of controlled substance, methamphetamine, trespass on school grounds, criminal mischief, child endangerment, and other petty thefts. He does have, according to our records here, no failures to appear, but The state's position would be a bond a little bit higher than $250 with the conditions of no alcohol or drugs, no hostile contact, and no weapons and firearms.
And Your Honor, may I be heard in response?
One moment. Do you have a position on the bond in the prior case?
In the prior case, we would ask for that to be revoked. We do realize that it's not been filed on, but we are still waiting the FDLE reports. I can look it up real quick to see.
Okay, that's, okay, yeah, well, briefly.
Your Honor, the state did list his prior history as far as arrest. All of those that were listed were not convictions, so I'd like the court to take note of that. It does appear that there are some convictions in his past, but according to the paperwork that was given, a good amount of those that the state did point out are arrests. Additionally, Your Honor, there was testimony that there's a 5-month-old child involved in which Mr. Jordan is a provider for, and it would be a hardship for the mother to continue to care for the 5-month-old child if Mr. Jordan is held. For those reasons, we would ask, additionally, $250 in a misdemeanor domestic battery is appropriate, so we would ask for a $250 bond amount. We have no objections to the additional conditions as far as no drugs or alcohol, no weapons, and no hostile contact. So, Your Honor, we would ask for there to be a $250 bond set in this case with those conditions. And again, we would ask the court to take no action on the case that he's out on bond for. As stated by the state and myself, there is no information filed on that case. The FDLE report will have to come back before the state attorney does file on it. And it is known that FDLE is completely backed up right now.
Okay, here's what I'm going to do. On the domestic violence battery charge on the new offense, I'll set bond in the amount of $250. That will be with conditions of no hostile contact, no possession or consumption of alcohol or drugs without a prescription, and Mr. Jordan will need to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. And what I'm doing, I'm taking into account the testimony of the alleged victim and the child care issues. I recognize that there is a prior arrest history, but without any, failures to appear or concerns about appearance, I think all of those conditions and a $250 bond amount are appropriate. With respect to the bond in case number 2022 CF 002546, under the circumstances, I'm going to take no action on that bond. I've considered the testimony that was given. I think that's appropriate here. So no action on the bond in the prior case. And with that, sir, that will conclude your initial appearance. And thank you very much, ma'am.
Thank you, Your Honor.
Or $100 for a bond.
Thank you very much. Okay, next do we have Ms. Pope?
What's your last name? Yes, Your Honor.
Okay, Ms. Pope, welcome. You're here today for an initial appearance. You're charged with domestic violence battery. You have the right to remain silent. Anything that you say may be used against you. You have the right to confer with counsel. If you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll go ahead and appoint the public defender. Reviewed the materials. I do find probable cause. Has there been any communication with the alleged victim?
No, sir, no communication.
Okay, let me hear from the parties on proposed conditions of release, defense and bond amount. And also, does she qualify for PTR?
Yes, sir.
Okay. Defense?
Your Honor, at this time, we'd ask for a $250 bond. The only condition to be no hostile contact and to maintain separate residences.
State?
Your Honor, the state at this time, no position on the bond amount. We are concerned about the alleged facts in this case, especially with the vehicle. I believe this is that case. No hostile contact, and no weapons or firearms.
Okay, here's what I'm going to do. I'll set bond in the amount of $250. That will be with conditions of no hostile contact, maintain separate residences with a one-time return with law enforcement assist to obtain any possessions.
I'm sorry, Judge, you said no hostile contact or no contact? You said no hostile.
Oh,
You told her
oh.
maintain, and then she can go back one time, so I want to make sure. Is it no contact or is it?
Your Honor,
It was, no,
Your Honor, they do not live together.
oh, okay, all right. So we'll just, I think the concept would be, they're not living together now, but maintain separate residences. They can have contact, just not hostile contact.
Okay.
And if Ms. Pope needs to return or needs to go to the residence to obtain anything, she can do so once with a law enforcement assist. Surrender any weapons or firearms to law enforcement within 24 hours. And no possession of weapons or firearms. Okay, one moment. Okay, and with that, that will conclude your initial appearance. Thank you very much, ma'am. Okay, do we have Mr. Thomas? Mr. Thomas, is that correct?
Yes, sir.
Okay, welcome, Mr. Thomas. You're here today for an initial appearance in one moment. You're here today for an initial appearance with a charge of domestic violence battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to consult with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender. Reviewed the materials. I do find probable cause. Okay, has there been any communication with the alleged victim?
No, sir, voicemail was left for the victim.
Okay, let me hear from the parties on proposed bond amount and conditions of release. Defense?
Your Honor, we would be asking for a $250 bond, and a one-time return if needed. Yes, Your Honor.
Okay, State?
Your Honor, no position toward the bond amount. We would be asking for no contact with one separate residence, one return, and I think that that will be it.
Okay, I'll set bond in the amount of $250. That will be with conditions of no contact with the alleged victim, maintain separate residences with a one-time return with law enforcement assist to obtain any possessions. And with that, sir, that will conclude your initial appearance. Thank you very much.
Your Honor, Alexander Absolute, bonded.
Hang on.
Anderson? The next one's Anderson?
He bonded on,
No, not this one.
He had a out of county.
right, that's, yeah, what I'm confused by, too.
He didn't bond? Or was he bonded? I apologize. If you give us a few minutes, we honor will bring the next person up, we'll call him back.
Sure.
He just sent him out, tell him to come back.
Did he bond on this one?
inside. Okay, do we have, is that, Mr. Anderson? Is that correct? Okay, he bonded. So that one bonded. Okay, Brian bonded.
Okay.
And do we have, is it Mr. Dean?
Yes, sir. Mr. Dion, yes.
Okay, welcome, Mr. Dean. You can walk up to the microphone. You're here today for an initial appearance, Mr. Dean, on charges of possession of MDMA, ecstasy, and possession of drug paraphernalia. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the Public Defender's Office will be appointed to represent you. Would you like the Public Defender appointed at this time?
Sure.
I'll go ahead and appoint the Public Defender. I've reviewed the materials. I do find probable cause I'm going to stay the bond amounts. So for count one, that'll be $1,000. For count two, that will be $500. That will be with the condition of no possession or consumption of alcohol or drugs without a prescription. In addition, Mr. Dean is out on bond in case, or out on PTD in case number 2021 CF 008216. And in that case, I will revoke the PTD and direct that Mr. Dean be held without bond at this time.
Your Honor, if I may be heard on the pretrial diversion?
Yes.
Your Honor, that case is currently closed in Judge Roche's courtroom because of pretrial diversion. For that reason, we'd ask for no action to be taken. If Mr. Dean would be rejected from pretrial release, it would go back to Judge Roche, but at this time, it does show as it's closed for the pretrial diversion. So I would ask for no action to be taken.
State?
If I might have one moment, Your Honor.
Yeah, I know. Okay, we can't fight that right now. You would have to tell the public defender.
The state does not have a position toward that case, Your Honor.
Okay, here's what I'm going to do. At this time, I'd like to allow Judge Roche to have an opportunity to address that issue. So I'll maintain that ruling with respect to the pretrial diversion.
Judge, did you address the 2019 00?
I don't have that one. Oh, I'm sorry. Yes, there's another case. Okay, and also, Mr. Dean, you're here as well on a failure to appear with an underlying charge of trespassing in an occupied conveyance. That is case number 2019 MM 007728. Same instructions apply here as well. You have the right to remain silent. Anything you say may be used against you. I'll appoint the public defender in this case as well. To the extent necessary, I find probable cause. I will, on that one, stay the bond in the amount of $500.
Your Honor,
Can I say something, Your Honor, please? The reason of both of the cases are like...
Good. Why don't you talk to your attorney?
Sir,
She probably don't understand what I'm saying.
Your Honor, can you clarify what's happening with the pretrial diversion? I'm sorry.
The pretrial diversion case, you're not revoking it, or are you taking no action on it?
No, I had revoked it.
Oh, you did revoked it and set it at 9?
Yes. So the intention there was to revoke and set at no bond until the issues can be addressed in front of Judge Roche.
Yes, Your Honor. Thank you, Your Honor.
Thank you very much, sir. With that, that will conclude your initial appearance. And next, do we have Mr. Edwards?
Yes, sir.
Okay, welcome, Mr. Edwards. You're here today for an initial appearance on a charge of sale and delivery of cocaine. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll appoint the public defender's office. I've reviewed the materials. I do find probable cause. I'm going to stay the bond in the amount of $15,000. That will be with a condition of no possession or consumption of alcohol or drugs without a prescription. In addition,
Your Honor, may we have one moment before we address the case that he's out on bond for? I'm trying to see if there was previously an offer relayed.
Ms. Cunningham, it's an adjudication, court cost of prosecution.
May I have just a moment, Your Honor?
yes, and while they're conferring, let me reiterate my offer. I'm going to keep going through unless somebody tells me they need a break, so don't be bashful about that. It should go quicker once we've gotten through DV. My practice on DV is to ask for everybody's position. The other cases should go a bit quicker. I don't typically do that with other cases. So if anybody needs a break, just let me know. Otherwise, I'm going to keep going through.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Yes.
For the driving while license suspended charge that he's out on bond for, the state has extended an offer of adjudication of guilt and credit for time served. Would the court be willing to take that offer at this time?
One moment.
Let me see.
It's on adjudication and credit.
Yesterday. Today's the first. Oh, for April 13th. Coming up on traffic.
Okay. Here's what I'm going. Okay, here's what I'm going to do. I'm going to take no action on the bond in that case. I'd rather you all address that in front of the presiding judge. So I'll take no action on the bond in case number 2019 CT 009070.
And Your Honor, I'm sorry, were we appointed to that case? I'm not seeing it in my system, so I'm not sure.
Medling, Catherine Medling, M-E-D-L-I-N-G.
Is that a private attorney? You have a private attorney in that other case?
Okay.
It seems so, Your Honor. It seems that she's a private attorney.
Okay.
Okay, so in light of the anticipation there, I'll take no action on that and just allow you all to address that in front of the presiding judge.
Thank you, Your Honor.
Thank you very much, sir.
But his bond say 15.
15,000.
No special condition, right?
Oh, no drugs or alcohol.
Oh, drugs, alcohol, okay.
Okay, do we have Mr. Fell?
Yes, sir.
Okay, welcome, Mr. Fell. You're here today for an initial appearance. You have the right to remain silent, I'm sorry, you're here on underlying charge, you're here on charges of aggravated assault with a firearm, possession of a firearm by a convicted felon, and improper exhibition of a weapon or firearm. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to set bond on count 1 in the amount of $2,500. I'll stay the bond on count 2 in the amount of $4,000. I'll stay the bond on count 3 in the amount of $250. That will be with conditions that there be no contact with the alleged victim, and that any weapons or firearms be surrendered to law enforcement within 24 hours, and that Mr. Fell not possess weapons or firearms. And with that, sir, that will conclude your initial appearance. Thank you very much. Okay. Next.
We have Absolute Alexander.
Okay. So, welcome, Mr. Absolute. You're here today for an initial appearance. And just so that I can clarify the situation, did he bond out on the first, did he bond out on anything?
Well, someone from downstairs called us and told us he bonded, so we're not sure. It just said that he bonded, so he was here in the back when we sent him downstairs because of the paperwork they told us he bonded. So we're not sure if he bonded on anything at all right at this moment. The clerk may be able to, may be able to look it up real quick.
Check.
Did not? Okay, okay. All right, Mr. Absolute, you're here today for an initial appearance in 2 cases. One is a charge of carrying a concealed firearm. The other is a violation of probation on an out-of-county warrant with an underlying charge of obstructing a criminal investigation. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel. If you cannot afford an attorney, the public defender will be appointed to represent you. And the materials I have here indicate that you do not qualify for the public defender, so the public defender will not be appointed at this time. With respect to the charge of carrying a concealed firearm, I do find probable cause. I will stay the bond in the amount of $2,500. That will be with the condition that you surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. So that was case number 22 CF 2756. Case number, I don't know if we have a, let me see, case number, but the other case is an out-of-county warrant, violation of probation. Again, the underlying charge is obstructing a criminal investigation. With respect to that charge, I do, to the extent necessary, find probable cause, and I'll direct that you be held without bond at this time. So thank you very much. Sir, with that, that will conclude your initial appearance.
Who's the next one? I'm trying to figure out.
Okay, Fogg bonded out. Okay, bonded.
That's Hall.
Okay, welcome, sir. Do we have Mr. Hall?
How you doing, sir?
I'm doing very well, thank you. Mr. Hall, you're here today for an initial appearance on charges of possession of cocaine, possession of cannabis, less than 20 grams, and possession of drug paraphernalia. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to stay the bond amounts. Count 1 is $1,000. Count 2 is $100. Count 3 is $100. That will be with a condition of no consumption or possession of alcohol or drugs without a prescription. And with that, sir, that will conclude your initial appearance today. Thank you very much.
There you go.
Okay, welcome. Ma'am, do we have Ms. Hazley?
Yes, Your Honor, I'm here.
Okay, welcome, Ms. Hazley. You're here today for an initial appearance. You've been charged with a count of petite theft with 2 prior convictions and resisting an officer without violence. You have the right to remain silent. Anything you say may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir. Thank you.
I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to stay the bond amounts. So for count 1, that will be $1,000. For count 2, that will be $500. That will be with a condition of no return to the scene of the offense. In addition, Ms. Hazley is out on ROR in several cases. For case number 2021 CF 003081, I'm going to revoke the ROR and direct that Ms. Hazley be held without bond at this time. On case number 2022 CF 000161, I'm also going to revoke the ROR and direct that Ms. Hazley be held without bond at this time. On case number 2021 CF 002875, I'm also going to revoke the ROR and direct that Ms. Hazley be held without bond at this time. And that will conclude your initial appearance. Thank you very much, ma'am. Oh, I'm sorry. Okay, what's the other one?
2021 CF 008528. It's open.
Okay, that one I do not. And is she out on bond or ROR? What's the?
It's just open case, Judge. It's for petty theft, 2 trials, conviction, and
What's the case number?
it's 2021 CF 008538.
That's the Orange County Osceola. Because these cases here is Osceola.
All of those cases I went through were Osceola.
Oh, yeah, and you revoked those, yes. Yes, Osceola also? Okay.
Yeah. The one that you just said, it was closed on 3/8, Your Honor.
Oh, that one was played on 3. You said that case was played on 3/8?
Yeah, it was pled on 3/8.
Okay, so nothing to do there then. Okay, thank you very much, ma'am. That will conclude your initial appearance.
So you take no action on that, right, Judge?
She planned on it.
Oh, yeah, so no action on that one. Okay, do we have Mr. Hooks? Is that correct? Okay, welcome, Mr. Hooks. You're here today for an initial appearance on a charge of resisting an officer and fleeing or eluding a law enforcement officer with lights and sirens activated. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to set bond on that charge in the amount of $3,500. $3,500. In addition, Mr. Hooks is out on bond in case number 2021 CF 012402. In that case, I'll revoke the bond and direct that Mr. Hooks be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much, sir.
You said that 3,000.
3,500.
Oh, 3,500.
Yep, 3,500. Okay, do we have
Johnson?
Mr. Johnson?
Sir.
Okay, I get Mr. Johnson. Thank you very much, sir. You're here today for an initial appearance. You've been charged with possession of a weapon or ammunition by a convicted felon and aggravated assault with a deadly weapon without intent to kill. You have the right to remain silent. Anything that you say here may be used against you. And you've also got a second case. One moment. Nope, never mind. Okay. Never mind. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel. If you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Sure.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. And I'm going to set bond on count 1 in the amount of $5,000, count 2 in the amount of $2,500. That will be with the conditions of no contact with the alleged victim, no return to the scene of the alleged offense. Mr. Johnson will need to surrender any weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. And in addition, Mr. Johnson is out on ROR in case number 2021 CF 016308. I'm going to revoke the ROR in that case and direct that Mr. Johnson be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much, sir.
But not on when you were out on.
Your Honor, Jones dignity refused.
Okay. So for Mr. Jones, would you be in a position to waive, or would you like that to be reset?
Your Honor, are we appointed to this case?
Not yet, but well, so it was just a refusal? Okay, here's what I'm going to do. Let's go forward, Mr. Jones. His initial appearance is on charges of possession of drug paraphernalia, possession of cannabis over 20 grams. I'm going to appoint the public defender. Based on the refusal, I'm going to find appearance waived. I've reviewed the materials. I do find probable cause. I'm going to stay the bonds for count 1 in the amount of $200, count 2 in the amount of $2,000. That will be with the condition that Mr. Jones not possess or consume alcohol or drugs without a prescription. And that will conclude Mr. Jones' initial appearance. Okay, now, and do we have Omari Jones?
I believe this is Miss McLeroy.
The booking number.
Okay, one moment. I also have an Omari Jones, and let's see, you all would know where the booking number, it's a 22005720.
Yep, that's it.
Bonded.
Bonded, okay. And do we have Ms. McElroy? Okay, welcome, ma'am. You're here today for an initial appearance on charges of possession of cocaine and possession of drug paraphernalia. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender's office will be appointed to represent you. Would you like the public defender appointed at this time? Yes. Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. For count one, I will stay the bond in the amount of $1,000. For count two, I will stay the bond in the amount of $100. That will be with the condition that you not possess or consume alcohol or drugs without a prescription. In addition, Ms. McElroy is out on bond in case number 2020 CF 010241. For that case, I'm going to revoke the bond and direct that Ms. McElroy be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much, ma'am. Oh, I'm sorry, there's another one? What's the other one?
She's out of bond. It's 2020 PT 005219.
2020 CT
5219.
I don't have that one in front of me. Well, I want to know, is there a bond?
Let me see. Sorry, Judge. I'm sorry, Judge.
That's okay.
Bond is going to be I understand.
2020 CT 5219. No, don't worry about it.
5219. It was $100 bond.
There's a bond in that case as well?
Yes.
Okay, then on case number 2020 CT 5219, Ms. McElroy is also out on bond in that case. I'm going to revoke the bond and direct that she be held without bond in that case as well. So with that, that will conclude your initial appearance. Thank you very much, ma'am. Okay, next I've got Mr. Miles. Hey, welcome, Mr. Miles. You're here today for an initial appearance. You're here on two cases. Excuse me. In case number 2022 CF 2744, you've been charged with possession of MDMA ecstasy, possession of cannabis under 20 grams, and possession of drug paraphernalia. In case number 2021 CF 1250, that's a violation of a condition of pretrial release with an underlying offense of possession of Eutalone. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay. I'll appoint the public defender in both cases. In case number 2022 CF 002744, I do find probable cause. I'm going to stay the bonds in the amount of $1,000 for count one, $100 for count two, $100 for count three.
Your Honor, if I may?
Yes.
We would ask for ROR on the possession of cannabis because the state isn't prosecuting on under 20 grams.
Okay. State?
That is correct, Your Honor. The state's position would also be ROR.
Okay, so then with respect,
I'm sorry, Your Honor. What was said?
I'm sorry, with respect to count two then, that count will be set at ROR. Count one will be $1,000. Count three will be $100. So count one is 1,000, count two ROR, count three 100. That will be with the condition that Mr. Miles not possess or consume alcohol or drugs without a prescription. On case number 2021 CF 001250, to the extent necessary, I find probable cause. I'll find that on that case, I will direct that Mr. Miles be held without bond at this time. And that will conclude your initial appearance. Thank you very much, sir. Is that enough revoked pretrial release? Do we have, is Mr. Ramsey?
Yes, sir.
Okay, welcome, Mr. Ramsey. You're here today for an initial appearance in two cases. In case number 2022 CF 002236, you've been charged with petite theft with 2 prior convictions. In case number 2022 CF 002736, you've also been charged with petite theft with 2 prior convictions. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
I'll go ahead and appoint the public defender in both cases. In case number 2022 CF 002236, I'm going to stay the bond in the amount of $1,000. That will be with conditions of no return to the scene of the alleged offense, no contact with the alleged victim. And I do find probable cause, if I haven't said that already, to the extent necessary. In case number 2022 CF 002736, find probable cause in that case. I'm also going to stay the bond in the amount of $1,000, and that will be with conditions of no return to the scene of the alleged offense and no contact with the alleged victim. So with that, sir, that will conclude your initial appearance. Thank you very much.
Your Honor, Ransom, Rajan bonded.
Okay, bonded in both cases? Okay. Bonded. And next, do we have Mr. Riddle, is that correct?
Mr. Riddle?
Mr. Riddle?
Yes, sir.
Okay, welcome, Mr. Riddle. You're here today for an initial appearance. You've been charged with petite theft with 2 prior convictions. You have the right to remain silent.
Two theft.
No.
Your petite theft with 2 prior convictions. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. It's a warrant, but to the extent necessary, I find probable cause. I'm going to maintain the bond amount. I'll say the bond amount of $2,000 and maintain the conditions of no return to the scene of the alleged offense and no contact with the alleged victim. And with that, sir, that will conclude your initial appearance. Thank you very much. Okay, do we have Ms. Skidmore? Okay, welcome, Ms. Skidmore. You're here today for an initial appearance. You've been charged with possession of heroin with the intent to sell or deliver. You've been also charged with grand theft of a motor vehicle and petite theft, larceny in the second degree for a first offense. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
No, thank you.
You don't want the public defender appointed?
My attorney was supposed to be here.
Oh, you have a private attorney. Okay. I don't believe that we have anyone else here in terms of private attorneys, but what I'm going to do is...
Can you appoint me one anyways, just in case?
Okay. I'll go ahead and appoint the public defender at this time then.
Your Honor, may I be heard as to probable cause on this case?
Yes, ma'am.
Your Honor, there's no probable cause for intent to sell or deliver. There may be probable cause of possession of something, but it just states that it was tested. It doesn't say what it tested positive for. And as far as intent or to sell or deliver, there's nothing within the 4 corners of the affidavit to state that.
Okay, state.
Your Honor, the state would ask for this to be reset.
And Your Honor, again, I would object. She is here within the 24 hours of her arrest for her initial appearance. The affidavit, besides what it tested presumptive positive for. It does state to be complete. It doesn't seem that there's something missing as far as evidence that was found. So I believe that there may be probable cause for possession of a controlled substance, but intent to sell or deliver, there is absolutely nothing to point to that.
Okay, what I'm going to do at this time is that I'll reset and allow the state an opportunity to establish probable cause.
The bond gonna stay, Judge?
For the time being, the bond amounts will be stayed at where they are, and we'll reset for tomorrow to allow the state an opportunity to establish probable cause.
That was as to, I guess the whole thing, or just?
And but before we go, by the way, are you all, is anybody asking for a probable cause determination on the other two accounts? Or?
Your Honor, I'm not challenging a probable cause on the other two amounts, but we would ask for them all to be heard at the same time tomorrow.
That's fine. We'll just reset them all for tomorrow then. Okay. Next, do we have Mr. Taylor? Is that correct? Okay. Welcome, Mr. Taylor. You're here for an initial appearance in two cases. For case number 2022 CF 002750. You've been charged with a traffic violation, driving with a license suspended by a habitual offender. In addition, in case number 2022 MM 000155, you've been charged with making a false report, knowingly giving false information to a law enforcement officer. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
I have an attorney, but
You have your own attorney?
I'll contact him. I haven't contacted him yet.
Okay, so
For this case here, just for the bond, they could reinstate the old bond.
well, I'm sorry, I'm having trouble here. Would you like me to appoint the public defender at this time?
And he have a private attorney on the case he out on bond. Oh, how you pronounce that last name? Seidule? Nicholas?
Sadul? Okay, yeah, he is a private attorney.
On his case he out on bond, yes.
Okay, you've got, and I apologize for interrupting you. It looks like you have an attorney on the case that you're out on bond on. I don't know if you'd like the public defender appointed for these cases.
Your Honor, just a moment.
This is out on bond.
Your Honor, he's asking for the public defender's office to be appointed.
Okay, I'll appoint the public defender in both of these cases.
I'm sorry, Judge, the case that he's out on bond, he has a private attorney.
There's two cases that he's.
That he's, okay, I'm sorry.
Right, so and by the way, by the two cases, I mean case number 2022 CF 2750 and 2022 MM 000155. I'm not talking about the case where Mr. Taylor's out on bond. So for case, I've reviewed the materials for case number 2022 CF 002750. I do find probable cause. I'm going to stay the bond in the amount of $2,500. In case number 2022 MM 000155, I also find probable cause. I'm going to stay the bond in the amount of $500 in that case. Mr. Taylor is also out on bond in case number 2021 CF 009098. In that case, I'm going to revoke the bond and direct that Mr. Taylor be held without bond at this time. With that, sir, that will conclude your initial appearance. Thank you very much.
You're on a Tingling, Connor.
He's bonded? Okay, thank you. Okay, do we have Ms. Tucker? Okay, welcome, Ms. Tucker. You're here today for an initial appearance on a charge of violation of a condition of pretrial release. Underlying offenses are trafficking in oxycodone, possession of L-Prazolam, intent to sell or possess, and intent to sell or possess cocaine. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed?
I have an attorney. Kendall Horween is my attorney.
Okay, so you've got an attorney, and I won't appoint the public defender at this time. Reviewed the materials to the extent necessary. I do find probable cause. I'm going to direct that the pretrial release be revoked and that Ms. Tucker be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much.
Your Honor, White, Alama.
Your Honor, we would ask for this to be reset. There's an offer on this case.
Hang on. Just a moment.
You're not on the felony. We don't do felony officers. What's his name?
Last name White.
Well, there's...
Oh, on a misdemeanor, but his felony case. Yeah. Okay.
Well, hold on one moment. Yeah, there's a felony case and a misdemeanor case. Well, there's a failure to appear in the misdemeanor case. So I think we're just going to need to go forward with the initial appearance on that one. In light of his, so next we've got Mr. White. He's here for an initial appearance on two cases. He's refused to appear. I'm going to find appearance waived. First case is case number 2022 CF 002711. Those are charges of burglary of a conveyance and grand theft, third degree. In that case, I'm going to appoint the public defender. I'm going to stay the bond in the amount of $3,500 in count one, $150 on count two. That will be with conditions of no return to the scene of the alleged offense, no contact with the alleged victim, and surrender weapons or firearms to law enforcement within 24 hours. Do not possess weapons or firearms. With respect to case number 2021 MM008972, I'm also going to find appearance waived. That is for a failure to appear, the underlying charge of trespass on property after warning. I'll also appoint the public defender in that case, and I'm going to stay the bond in the amount of $2,000. In addition, Mr. White is out on ROR in case number 2022 CF 000252. In that case, I'm going to revoke the ROR and direct that Mr. White be held without bond at this time. Okay. Do we have Mr. Young?
Yes, sir.
Okay. Welcome, Mr. Young. You're here today for an initial appearance on a charge of aggravated child abuse. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
No, sir.
Did you say no? I'm sorry.
No, sir.
No, sir. Okay. So I will not appoint the public defender at this time. I've reviewed the materials. It's a warrant, but to the extent necessary, I find probable cause. Has there been any input from the alleged victim or the family? Okay. Okay. Here's what I'm going to do. I will set bond in the amount of $5,000. I'll maintain the condition in the warrant, which is no contact with the alleged victim. In addition, Mr. Young is out on bond in case number 2021 CF 007128. In that case, I'm going to revoke the bond and direct that Mr. Young be held without bond at this time. In addition, Mr. Young is out on bond in case number 2019 CF 003378. And in that case, I'm also, it's bond and PTR. I'll revoke the bond PTR and direct that Mr. Young be held without bond at this time. So with that, sir, that will conclude your initial appearance. Thank you very much. Okay, do we have Mr.
Yeah, he bonded, she bonded.
A Strachan bonded? Okay, bonded.
Garcia, 5 Melvin bonded.
Okay, Melvin bonded as well, okay.
Golden Maldonado Omar bonded.
Also bonded, okay. And do we have, is it Mr. Hall?
Sir.
Okay, welcome, Mr. Hall. You're here today for an initial appearance. You've been charged with reckless driving. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
I think so, yes.
Okay, I'll appoint the public defender to represent you. I've reviewed the materials. I do find probable cause. I'm going to stay the bond in the amount of $500. In addition, Mr. Hall is out on bond in case number 2021 CF 001887. In that case, I'm going to revoke the bond and direct that Mr. Hall be held without bond at this time. So with that, sir, that will conclude your initial appearance. Thank you very much.
Your Honor.
That's yours.
Colbert Charles, he bonded.
Yep, bonded.
Rivera Antunez, Jose, also bonded.
Okay. Okay, next we have, is it Mr. Bautista?
Yes.
Okay, welcome, Mr. Bautista. You're here today for an initial appearance. You've been charged with battery. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney. If you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time? Yes. Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to stay the bond in the amount of $500. I'm sorry?
PTR.
Okay, for this one, I'm going to set the bond in the amount of, no PTR, I'm going to set the bond in the amount of $500. That will be with conditions of no contact with the alleged victim. And one moment. I know from what I've seen, it looks like it may be a prior relationship, but nevertheless, maintain separate residences. If there are any possessions at the residence of the alleged victim, you can return one time with the assistance of law enforcement. Surrender any weapons or firearms to law enforcement within 24 hours. Do not possess weapons or firearms. And with that, that will conclude your initial appearance. Thank you very much, sir. Okay, do we have, is it Mr. Briseno Lugo?
Yes.
Okay, welcome, Mr. Briseno Lugo. You're here today for an initial appearance. You've been charged with retail petite theft. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
You have to.
Yes, okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause. I'm going to stay the bond in the amount of $250. That will be with the condition of no return to the scene of the alleged offense. In addition, Mr. Briseno Lugo is out on bond in case number 2020, or out on ROR in case number 2022 CF 002250. In that case, I'm going to revoke the ROR and direct that Mr. Briseno Lugo be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much, sir.
This is for you.
Do we have? Okay, then we will. Okay, let's reset Ms. Ward for tomorrow based on mental health. Okay, next, Woodard.
Woodard Marcia, bonded.
Okay, bonded. Do we have, is it Mr. Xavier?
Yes, sir.
Okay, welcome, Mr. Xavier. You're here today for an initial appearance. You have the right to remain silent. Anything that you say here may be used against you. You've been charged with trespassing on property after a warning and possession of cannabis under 20 grams. You have the right to confer with counsel, and if you cannot afford counsel, the public defender will be appointed to represent you. Would you like the public defender appointed at this time? I'll appoint the public defender. What's that? Okay, he does qualify for PTR. Okay, I've reviewed the materials. I do find probable cause. I will, one moment. I will direct that Mr. Xavier be released on PTR with conditions of no return to the scene of the alleged offense, no possession or consumption of alcohol or drugs without a prescription. And with that, sir, that will conclude your initial appearance. Thank you very much.
Yeah, straight PTR.
Yes. Okay, do we have, is it Mr. Premsuk? Okay, welcome, Mr. Premsuk. You're here today for an initial appearance. You're here on an out-of-county warrant with an underlying charge of an issue involving a financially responsible driving bond. You have the right to remain silent. Anything that you say here may be used against you. And what I'm going to do is direct that Mr. Premsuk be held without bond at this time on the out-of-county warrant. And with that, that will conclude your initial appearance. Thank you very much.
Judge or no?
Not on an out-of-county warrant. Okay, do we have Mr. Rivera? Okay, give me just one moment.
You should have, you do, I think, 4 cases.
1, 2, 3.
All that I feel the yes.
Is it? Okay, that's the same case. Okay. 2, 3, 4. And that's the same one. Okay. All right, Mr. Rivera, welcome. You're here for an initial appearance on several out-of-county warrants. You have the right to remain silent. Anything that you say here may be used against you. I'm going to go by case number for case number 21 CF 163. It's an out-of-county warrant with an underlying offense of fleeing and eluding. That warrant, I'm going to direct that you be held without bond. On case number 2021 CF 3209, you're also here on out-of-county warrants, underlying possessions of sale of cocaine, sale of heroin. For those warrants, I'm going to stay the bonds in the amount of $7,500, $7,500, and $250. For case number 2021 CF 21 CF 267, you're also here on out-of-county warrant with an underlying offense of fleeing and eluding. For that warrant, I'll direct that you be held without bond. Case number 2022 CF 000495, you're here on out-of-county warrants with underlying offenses of driving with a license suspended, third offense, and an unregistered motor vehicle. For those warrants, I'll stay the bonds in the amount of $2,000 and $250. And with that, that will conclude your initial appearance. Thank you very much, sir. Okay. Next, do we have Mr. Santiago? Okay, welcome, Mr. Santiago. You're here today for an initial appearance on out-of-county warrants with underlying offenses of attempted murder without premeditation, shooting into an occupied vehicle, and direct discharge of a firearm from a vehicle. You have the right to remain silent. Anything that you say here may be used against you. I'm going to, on the first offense, the attempted murder warrant, that will be, I'll direct that you be held without bond. On the second warrant for shooting into an occupied vehicle, on the second charge for shooting into an occupied vehicle, I'll stay the bond in the amount of $10,000. And then on the direct discharge of a firearm from a vehicle, I'll stay the bond in the amount of $5,000. And with that, that will conclude your initial appearance. Thank you very much, sir. Okay. Do we have Mr. Baker? Okay, welcome, Mr. Baker. You're here today for an initial appearance. You've been charged with violation of probation with underlying offenses of burglary and assault. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time? Okay, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause, and I will direct that Mr. Baker be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much, sir. Okay, do we have, is this McCree?
No, he refused, Your Honor.
Okay, for Mr. McCree, we'll go forward with his initial appearance. He's here on a charge of violation of probation with an underlying offense of petite theft with 2 prior convictions. I'll appoint the public defender. Reviewed the materials. To the extent necessary, I do find probable cause, and I will direct, I'll find appearance waived, and I will direct that Mr. McCree be held without bond at this time. Okay, next we have Ms. Stafford. Is that correct? Yes. Okay, welcome, Ms. Stafford. You're here today for an initial appearance. You've been charged with the violation of probation with an underlying offense of grand theft. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with counsel. And if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed?
Yes, sir.
Yeah, I'll appoint the public defender at this time. I've reviewed the materials. I do find probable cause to the extent necessary, and I will direct that Ms. Stafford be held without bond at this time. So with that, that will conclude your initial appearance. Thank you very much.
You don't tell me, can you tell me about violation?
I can't right now.
Okay, do we have Mr. Taylor? Yes, sir. Is that correct? Okay, welcome, Mr. Taylor. You're here for an initial appearance. Let's see, is it 3 matters?
Yes, he got a on VVOP, FTA, same case, and he got charged.
Okay, so Mr. Taylor, you're here in a number of matters. You've been charged with a violation of probation and several failures to appear, and carrying a concealed firearm, possession of cannabis under 20 grams. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time? Okay, I'll go ahead and appoint the public defender. In case number 2018 CF 8984, you've been charged with a violation of probation with underlying offenses of trafficking in stolen property, burglary of an occupied structure or conveyance, and providing false information to a pawnbroker. In that case, to the extent necessary, I find probable cause, and I'll direct that you be held without bond at this time. In case number 2018 CF 008984, same case, you've also been charged with failures to appear. And underlying offenses are dealing in stolen property, burglary of a conveyance. In that case, I'll direct that you be held without bond. In case number 2022 CF 002747, you've been charged with carrying a concealed firearm and possession of cannabis under 20 grams. I've reviewed the materials. I do find probable cause, and I'm going to stay the bonds in the amount of $2,500 for count 1, $100 for count 2, and that will be with the condition that you not possess or consume alcohol or drugs without a prescription.
Your Honor, we'd ask for ROR on the cannabis charge because the state of Florida is not prosecuting under 20 grams.
State?
No objection, Your Honor.
Okay, then, oh, I'm sorry. Okay, let me go back to that last one. So I'll stay the bond in the amount of $2,500 on count 1. For count 2, that will be ROR, and the condition will instead be that Mr. Taylor that he surrender weapons or firearms to law enforcement within 24 hours and not possess weapons or firearms. So with that, that will conclude your initial appearance. Thank you very much, sir.
So the possession strike that one?
Yeah.
Okay, just no weapons.
Okay. And then do we have Mr. Gabrielson? Yes, sir. Okay, welcome, Mr. Gabrielson. You are here for an initial appearance, the charge of soliciting without a permit. You have the right to remain silent. Anything that you say here may be used against you. You have the right to confer with an attorney, and if you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes.
Okay, I'll appoint the public defender. I've reviewed the materials. I do find probable cause.
Your Honor,
And yes?
the state of Florida has extended an offer on this case of an adjudication of guilt and credit for time served in court costs. Will the court be willing to accept that plea at this time?
I would be inclined to accept it. State, is that correct?
Yes, Your Honor.
Your Honor, may I approach with the signed plea form?
Yes, ma'am. Thank you. Okay, just one moment. Okay, is there a plea offer?
Your Honor, the offer is an adjudication of guilt, credit for time served in court costs. I did write it on the plea form that was given to you.
Thank you very much. Sir, can I ask you to raise your right hand? Do you swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, do you understand the plea that your attorney just announced in court?
Yes.
Do you understand that in entering a plea, there will not be a trial on this matter or the presentation of any evidence, and that you will be found guilty of the offense of soliciting without a permit?
Yes.
Okay, do you understand that you will be sentenced to, is it 2 days?
2 days.
To 2 days with credit for 2 days of time served?
Yes.
And do you understand that you will be responsible for court costs in the amount of?
223.
How much time is it?
223.
Is it a year to pay it?
Yeah. You give
Okay,
me a-
and that you'll be responsible for paying court costs in the amount of $223, and you'll have a year to pay those?
Yes.
Okay, has anything been promised to you in exchange for your plea?
No.
Has anyone threatened, coerced, or forced you into entering a plea at this time?
No.
Okay, the court finds that the plea is willingly and voluntarily made. The court accepts the plea and sentences Mr. Gabrielson to adjudicates him guilty of soliciting without a permit, sentences him to 2 days with a credit for 2 days of time served, and assesses court costs in the amount of $223, and they will be payable over a year.
Thank you, Your Honor.
Thank you.
Thank you very much, sir.
She needs a pen.
Okay, and next do we have Ms. Jenkins? Okay, welcome, Ms. Jenkins. You're here today for an initial appearance. You've been charged with soliciting without a permit, and you have the right to remain silent. Anything you say here may be used against you. You have the right to confer with an attorney. If you cannot afford an attorney, the public defender will be appointed to represent you. Do you want the public defender appointed?
Yeah.
Okay, I'll appoint the public defender. I reviewed the material. I do find probable cause.
Your Honor, the state of Florida has extended an offer of an adjudication of guilt, credit for time served and court costs. Would the court be willing to accept that at this time?
Yes, I would. Is that correct?
That is our offer, Your Honor.
Okay, do you have a plea offer at this time?
I do. May I approach?
Yes. Okay. And what is the plea that's being entered?
An adjudication of guilt, credit for time served and court costs.
Okay, ma'am, can I please ask you to raise your right hand? Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Do you understand what your attorney just announced to the court?
Yes, sir.
Okay, and do you understand that in entering a plea, there will not be a trial in this matter or the presentation of any evidence, and that you'll be found guilty of soliciting without a permit?
Yes, sir.
Do you understand that you will be sentenced to 2 days with a credit for 2 days of time served?
Yes, sir.
Do you understand that you'll be assessed court costs in the amount of $223 and that you'll have a year to pay those?
Yes, sir.
Okay, has anything been promised to you in exchange for your plea?
No.
Has anyone threatened, coerced, or forced you into entering a plea at this time?
No.
Okay, so the court finds that the plea is willingly and voluntarily made. The court accepts the plea and adjudicates Ms. Jenkins guilty of soliciting without a permit. I'll impose a sentence of 2 days with a credit for 2 days of time served and assess court costs in the amount of $223. Those will be payable over a year. So that will conclude the proceeding today. Thank you very much, ma'am. Best of luck to you. Okay, do we have Mr. Lattimore? Is that correct? Okay.
Yes, sir.
Welcome, Mr. Lattimore. You're here today for an initial appearance. You've been charged with loitering or prowling. You have the right to remain silent. Anything that you say here may be used against you. And you have the right to confer with an attorney. If you cannot afford an attorney, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Yes, sir.
Okay, I'll appoint the public defender. I've reviewed the materials. I do find probable cause.
Your Honor, this is a city case. Would the court be willing to extend an offer?
One moment. I'm not going to take an offer from the bench on this one. What I'm going to do is I'll do find probable cause. I'll stay the bond in the amount of $250. That will be with the condition of no return to the scene of the alleged offense.
Your Honor, if I may?
Yes.
Would the court be willing to do ROR on this case because it is loitering and prowling? I have discussed with Mr. Lattimore. He is unable to afford the bond.
Any objection to ROR?
No objection, Your Honor.
Okay, then I'll revisit that. I'll release Mr. Lattimore ROR with the condition of no return to the scene of the offense.
Thank you, Your Honor. Mr. Young?
Hi.
Okay, do we have Mr. Young?
Hi.
Okay, welcome, Mr. Young. You're here today for an initial appearance. You've been charged with an open container violation. You have the right to remain silent. Anything you say here may be used against you. You have the right to confer with counsel, and if you cannot afford counsel, the public defender will be appointed to represent you. Would you like the public defender appointed at this time?
Sure.
Yeah, I'll go ahead and appoint the public defender. I've reviewed the materials. I do find probable cause.
Your Honor, again, this is a city case. Would this court be willing to extend an offer since this is only an open container?
Yes, on this one I would. Is there a plea offer?
Your Honor, it's a city case, so the state is unable to give an offer at this time. The offer would come from the bench.
Okay, then on that, I would be willing to entertain a plea offer and impose sentence of 2 days? Or?
Yes.
2 days with credit for 2 days of time served and assess court costs.
223.
In the amount of $223 that would be payable over a year.
Your Honor, would that be a withhold of adjudication of or court costs? Or would that be a withhold or adjudication?
That would be an adjudication.
May I have a moment?
Yes.
Your Honor?
Yes.
At this time, Mr. Young would like to... Sorry, Your Honor, if I talk while I'm writing my bar number, I forget what it is. We'll accept the offer of an adjudication of guilt, credit for time served, and court costs. We plead no contest at this time. May I approach with the signed plea form?
Yes. That's okay.
Yeah, those are yours. Yeah. Okay.
Thanks.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.